Hi, folks. Welcome in. As you get settled, just take a look around the Zoom room. If you've been with us before, you know we use the Q&A and the chat function. Get settled. We'll get started in just a moment. All right. It looks like our numbers are settling, so I'm going to jump right in. Welcome. This is the Japanese American community in the U.S. Constitution. You're here with Japanese American Historical Society for the third in our series of Remembrance, Redress, and Reparation, Learning from the Past. This is part 3 of 3. So if you've joined us for all 3, if you've checked them out online, thank you so much for coming on this educational journey with us. We are going to start with our land acknowledgement that we do at the top of all of our programs. So I'll read this out as you kind of follow along, and we'll take a moment to think about it. For millennia, the Kumeyaay people have been part of this land. This land has nourished, healed, protected, and embraced them for many generations in a relationship of balance and harmony. The Japanese American Historical Society of San Diego acknowledges this legacy of balance and harmony, and we extend our gratitude and respect to the indigenous peoples for their past and continued care and stewardship. Another point I want to mention is that this is that third in that series. Oh, and I'm going to turn on my video. I realize I'm speaking to you incognito. We are thankful to California Humanities. It was made, this program was made possible by support from California Humanities. And so this part 3 of our 3-part series concludes that grant-funded programming, but do look for more from us. And with this continued support, we can reach you and more folks, and we can learn about this history together. At the end, I'm going to share this again, but do please keep in mind, because this is a grant-funded program, we do have some things we need to do. And one of them is to take a survey and make sure that our goals are being met. So your completion of this survey really, really does help us for this and for future programming. So I'll bring this up again at the end of the program, but it'll be that same link you've used before if you've taken the survey for our other programs as well. Just a reminder. And really quickly, we are going to be using the Q&A function for our questions. We'll have questions at the end of this program. You'll be here with us for until 11 o'clock for our program itself. And then if you can stay, that would be wonderful. We'll have questions and answers with our panelists to follow. So the program itself will end at 11 and we'll have Q&A after that. If you've got questions as they occur to you, please do type them in the Q&A box. It's the one that looks like 2 messages talking to each other. And if you do just want to say hello or share a connection or anything like that, please do. We welcome that in our chat box. So that's the one that looks like a single message bubble. If you do need transcription or closed captioning, it is available. You will have to enable it on your screen. It looks like a little CC like you see maybe on television. It's that same kind of button down at the bottom, right next to the Q&A button. We have enabled it, so if you do need to make use of closed captions or subtitles, please do use them. And we are recording, so if you have to leave or if you want to share this later with some folks, that will be available to you on YouTube. All right, I'm going to turn it over to Kay, who's going to introduce our speakers today, and then we will hear from them.
Thank you, Sam. Good morning to everyone, and welcome to today's webinar. I do want to mention that the program is sponsored not only by the Japanese American Historical Society of San Diego, but also by San Diego City College and by Palomar College, Asian Pacific Alliance and Higher Education. So we thank our sponsors. And yes, my name is Kei Ochi, and I am currently the president of the Japanese American Historical Society of San Diego. Nikkei, that is persons of Japanese ancestry, have been a vital part of San Diego since the 1880s. The Nikkei immigrants came here to work and to have better lives in America. And yes, like all immigrants, their lives were really hard, faced with discrimination, anti-Asian restrictions and laws that you will hear about today. But they persevered. And like most immigrants, they worked hard, raised their families, and their children were US citizens by birth. I am a Sansei, a 3rd-generation Japanese American, and my mom and dad, 2nd generation, were, although they were born here in the US and were citizens, they were incarcerated during World War II, along with almost 2,000 Japanese Americans from San Diego. And absolutely for no legitimate reason, but based solely on their ancestry. In all of the decades of Japanese in America, I believe that the most difficult years for our community very well could have been those war years. And if you've studied Asian American history and participated in previous webinars, you know about the targeting of the Japanese immigrants and Japanese Americans, on average for 3 years, violating civil and constitutional rights. And to speak about this abridgment of constitutional rights, it's my privilege to introduce today's speakers, Matthew Estes and Susan Hasegawa. First will be Matthew Estes. He's a professor of history at Palomar College, has been there for 17 years. He's worked full-time in education from the K-12 levels to community college for 27 years. He shared, and this is a quote, "My interest in researching the history of the Nikkei community, especially the internment, began at age 9, working with my dad. I have authored and co-authored articles on the Japanese American community for the Journal of San Diego History, the Journal of California History, and Great Plains Studies." And he said on a personal note, "My mother and her immediate family were evacuated during World War II, and her extended family was interned at Manzanar," end quote. Susan Hasegawa is a professor at San Diego City College and teaches US history and Asian American history. She has researched and written about the Japanese American experience in San Diego for the past 20 years. She has curated numerous exhibits, more than I can mention right now, but also importantly, based on oral history interviews and archival photographs, her community history, a book, Japanese Americans in San Diego, was published in 2008. In 2021, just this past year, Susan co-curated a fabulous exhibit, Call to Serve, Clara E. Breed and the Japanese American Incarceration, for the San Diego Public Library and our community. She grew up in Hana, a small town in East Maui, but is called San Diego home since moving here for graduate studies in 1989. So Matthew and Susan, I want to really thank you for being here. They were provided, their academia for the May 6th program and are back again today. So we'll begin. We'll start with Professor Matthew Estes.
Hello, I'm Matthew Estes, Professor of History at Palomar College, and for my part of the presentation, I'm going to set the historical context as far as the Asian American experience and the Constitution and the law. Now, I'm going to have to deal with both the Chinese and the Japanese immigrant experience very briefly, and then move on to the internment itself, but we do have to set the stage here. Now, one of the really important issues, constitutionally speaking, is the issue of citizenship. Now, since we're going to start off with the Asian immigrant experience, that brings up the question, what does the Constitution say about requirements for naturalization? That is, what is required to become a citizen if you come from somewhere else? Well, here's the thing. The Constitution itself has no requirements whatsoever about naturalization and citizenship. Now, what it does say is that Congress is responsible for this. It's under Article 1, Section 8 of the Constitution. That's that huge section of the Constitution that outlines all the powers of Congress. Now, or I should say, it outlines all the responsibilities of Congress, which includes things like taxation and tariffs, interstate and international trade, that sort of thing. But for us, the big one is Congress has the authority to oversee and set a policy for naturalization. And at the end of Article 1, Section 8, it says that Congress shall have the authority to make all laws which shall be necessary and proper to carry out into execution the foregoing powers. So what this means is Congress and Congress alone has the authority to set naturalization requirements, not the states. And we see from time to time, both in American history and even in certain cases today, the states trying to usurp that power. If they have a problem with national immigration policy, then they try to play fast and loose with who's a citizen, who can become a citizen, or who gets counted. Now, as far as what Congress did with this power, I want to do a quick history of that. So the first law that deals with naturalization is the Nationality Act of 1790. And in this, Congress said that a free white person who's lived for 2 years in the United States and 1 year in a specific state of the Union, if they can produce an affidavit of a good character, whatever that means, they can become a citizen of the United States. So by saying free white person, this specifically excluded indentured servants. Now, what that meant up until the Civil War and Reconstruction was if you were white and came from somewhere else, you could become a citizen. Now, after the Civil War, there was a problem. Well, there's a problem in all of America, but particularly in the post-Civil War South, the former Confederacy, of state governments trying to hold back the rights of African Americans, of the freedmen. So Congress authorized the 14th Amendment. Now, what this did is it said that citizenship will be conferred through the United States. And because you are a citizen of the United States, then you're a citizen of the state. So again, it says the states can't fool around with citizenship rights. Even though the 14th Amendment itself is written in race-neutral terms, it was specifically written and ratified to help the freedmen and their descendants. So what this means is if you are of African descent and come from somewhere else now, you can become a citizen of the United States. But for a long time, the courts basically ruled that there was no box for other. There's white and there's black, and that's pretty much it. Now, this is going to be codified into law in 1882 with the Chinese Exclusion Act. And here we can see not just, isolationism, but also this kind of scientific racism. Now, obviously, the Chinese Exclusion Act held up all Chinese immigration to the United States. Actually, it held up all Mongolian, people of Mongolian race coming. That was that kind of, quote, scientific view of race. But it said that all members of the, quote, Mongolian race are now aliens ineligible for citizenship. So in practice, what that meant is if you are Chinese or Japanese or Korean, you cannot become a citizen. Now, there will be laws carved out with exceptions for very specific groups in the future, but pretty much until the 1950s, that's the way it's going to be. If you are an Asian and you immigrate, you cannot become a citizen. Now, that brings us to the issue of what if you're born here? And that is legally known as the concept of jus soli, or by the right of the soil. And it brings us to the Supreme Court case of the United States versus Wong Kim Ark. Now, Wong Kim Ark was born in San Francisco to Chinese immigrant parents. He then had left the United States and gone to China to visit family and to conduct business in China, and then returned. When he returned to the United States, he was denied entry because they said, you are an alien who's ineligible for citizenship. And Wong Kim Ark, produced his birth certificate saying, well, no, actually, I was born in San Francisco, so I'm an American citizen. The argument of the United States government was that, well, since his parents were aliens who are ineligible for citizenship, that means he also is an alien ineligible for citizenship. They can't, it can't pass to the kid. When it went to court, the court actually said that, well, nope, that's not how this works. The 14th Amendment's pretty clear that if you are born here and your parents are not members of somebody else's diplomatic corps, then you are a citizen of the United States. So for our discussion about the Japanese American experience and the internment, what this means is the Japanese, the Nisei, the Japanese Americans, they are, by constitutional and case law, they're citizens of the United States. Now, I want to hit really quickly the 14th Amendment, another part of the 14th Amendment, and that would be the Equal Protection of the Law Clause. This basically says that no state shall deprive any person of life, liberty, or property without due process of law, nor deny to anyone the equal protection of the law. Now, some people argued that this applied only to U.S. citizens. Well, that was shot down in the Federal Circuit Court case of Hasegawa v. Noonan in 1879. Now, in this, Hasegawa had been arrested and held, and let's face it, mistreated under several San Francisco laws that were targeted specifically against the Chinese. And when he sued in court saying that his 14th Amendment rights have been violated, the county of San Francisco and the state of California had said that, well, he's not a citizen and the 14th Amendment does not apply. The Federal Circuit Court disagreed and said, no, actually, that's not the way this works. The 14th Amendment specifically says that the state shall not deprive any person, and they go on to clarify, dropping the distinctive term of citizen, and then of life, liberty, or property without due process of law. So what that means is, under case law, the 14th Amendment applies to non-citizens, that your immigration status does not matter. Now, how does this play out as far as the Japanese-American experience, especially in California? Well, in 1913, California passed what is known as the Webb-Haney Act, otherwise known as the California Alien Land Law. Now, in this, it basically said that, well, if you are an alien who's ineligible for citizenship, meaning an Asian, you cannot own cannot own land in California. Now, they were really worried about farmland, but it was pretty much any land. Now, a workaround for this, for the Issei, that is to say Japanese immigrants, was to put the land in question into a trust in the name of their citizen children, because as citizens, they've got constitutional rights to property and equal protection of the law. Now, this practice was challenged in the California case of California versus Harada in 1918, where the state of California said, well, you know, this whole business of putting land into a trust for your kids is just a way to circumvent a legitimate concern of the state. And the kids really, they don't have the land. It's the parents. Well, what ended up happening was the Supreme Court said that, no, that doesn't fly, that the California's alien land law violates the children's 14th Amendment rights to equal protection and to property. So it basically said that, yeah, you can do this, and the citizen children do have these rights. However, that brings us to another fairly disturbing practice that wasn't unique to California. It was carried out all over the country. But this is how do you get rid of people and don't violate their 14th Amendment rights? Well, the way it worked in this particular case is the Harada family was eventually forced out of Riverside because of community hostility. Now, what this means is the community, people in the community, were practicing their protected First Amendment rights. They did things like put up a spite wall. I mean, they even called it that, where they put up this fence where they would write messages or put up posters that were very, let's face it, racist and derogatory and threatening to the Harada family, until finally the family decided it just wasn't worth it and left and just kind of abandoned the property. Here's another example of how to get around the 14th Amendment, because remember, the 14th Amendment says that no state shall deny anyone equal protection of the law. Well, this only comes into play when the state is an actor. So what we see here is a fairly famous picture of trying to keep neighborhoods segregated, and it does not violate the 14th Amendment because this is protected First Amendment free speech for the individual. And it gets even worse in some cases. And to take this specific incident, it even goes into protected First Amendment free speech for the press, where the Los Angeles Examiner ran a story in which they showed that picture, but they also pointed out, and they approved of this, where the Hollywood Protective Association pretty much said that their goal was to drive the Nikkei out of their neighborhood. And again, this was perfectly legally acceptable because this was not the state infringing on the rights of the Nikkei. This was American citizens and an American newspaper practicing their protected First Amendment right. Now, another right I want to discuss really quickly is the right to due process. And this is the whole thing about a trial by jury, the collection and production of evidence, that sort of thing. One of the things to remember is this falls under the title of habeas corpus. Now, pretty much all the rights we have as American citizens are delineated in the Bill of Rights, which are the first 10 amendments to the Constitution. It has to be important and pointed out here that one of the rights that actually was put in the body of the Constitution, so it's not a later add-on, was the right to habeas corpus. Basically, Article 1, Section 9 said that that's not going to be abridged by the government unless things get way out of hand. In particular, in case of a rebellion or invasion that is so bad, they've got to do it. So this basically gives us the broad strokes defining due process and its protection. And again, it sets the precedent about how important this is. Now, as far as due process protections, these are further outlined in the Bill of Rights, in particular with the Fourth Amendment that protects people from warrantless and unreasonable searches and seizures of property, either just to be seized or to be used against them. The Fifth Amendment that protects the people against the use of military law against civilians and also protects property rights. And the Sixth Amendment, which guarantees a trial by jury, access to the evidence, and legal counsel. So these are all rights guaranteed to people under the Bill of Rights and the body of the Constitution. Now, these were obviously violated during the internment, because after Pearl Harbor, by the evening of December 8th, 1941, over 1,200 leaders, Issei leaders of the community, were rounded up and held by the FBI. Again, without them being able to, they weren't even charged, so they couldn't make a defense against a charge. They were held in what's called custodial detention, and they were held for almost a year with no contact with their family, and obviously no contact with their lawyers. They couldn't mount a case to defend themselves. They were just held. Now, obviously, this is a violation of habeas corpus, so it's a violation of Article 1, Section 9, and it's a violation of all of the Fourth, Fifth, and Sixth Amendments. Now, some people try to defend this practice by saying, oh, well, there was a war on and everybody just believed it was necessary. I would say no. No, that is not the case. There were people that believed that this was an unconstitutional move, including people like Ralph Carr, the governor of Colorado, who had serious constitutional concerns about the internment, and who even said that if during the period of voluntary evacuation, the Nikkei wanted to come to Colorado, they were welcome. Now, of course, that was the end of Governor Carr's career, but it does put lie to the idea that everybody agreed at the time that the internment was a good thing. Now, perhaps one of the most disturbing issues constitutionally about the internment is Executive Order number 9066, because everything else in the internment pretty much flows from this. What this did, as an executive order, it gave the military almost unchecked authority. Now, one of the things that people tend to get wrong about 9066 is that it was aimed at the Japanese Americans. Here's the thing. Yes, it was used against the Japanese Americans, but the order itself does not name them. So basically, it says that this can be done to anybody. This makes 9066 even more dangerous. If it had been written in a way to specifically single out the Japanese Americans, then at least it would set the precedent that if you're going to go after a group, you've got to define that group, and that kind of limits the government power. But the problem is, this can be used against anybody. So what did 9066 actually do? What powers did it give the military? Well, first of all, it gave the military the authority, without any oversight from Congress, to set what was called exclusion zones. Now, it was done on the West Coast, but the way the executive order was written, they could set them up pretty much anywhere. The military also got to decide who is forced to leave those zones. And if there's anybody in those zones that the military wants to exclude, the military can provide them with accommodations, meaning they can put them in a camp. And it says that the military can do pretty much whatever it needs to get the job done, including co-opt federal, state, and local law enforcement to help out with this. So that's why historians say that this is a stunning, absolutely stunning violation of due process, because obviously it violates Article 1, Section 9 that guarantees due process to everybody. It violates the Fourth Amendment against unreasonable and warrantless searches and seizures. It violates the Fifth Amendment because, okay, this is the military subjecting civilians to military law, and once again, denying those civilians the right of due process. And it violates the Sixth Amendment because there were never any formal charges, let alone trial by jury, the chance to mount an adequate defense, or access to legal counsel. Now, as far as the issue of citizenship and due process, many people are familiar, or at least those of you who've studied the Japanese American experience in San Diego, with the interview that my father did with Dr. Roy Tanaka back in 1979. Now, because of a conversation Dr. Tanaka had on the telephone in January of 1942, the FBI arrested him and held him in detention for hours and grilled him. And it is obvious when you read the interview, they had tapped his phone, which again, even though is legal in 1942, the court will later argue in the 1960s that, well, no, a warrantless wiretap is not cool. But they had done this kind of blanket to the entire Japanese American community. And when Dr. Tanaka asserted his rights as an American citizen because he was Nisei, born in this country, the special agent in charge said, well, you know, if I were you, I wouldn't use your rights as an American citizen just now, which is pretty terrifying. Now, one of the next steps, in addition to this arrest and detention of the Nikkei, were the civilian exclusion orders, which were issued in April of 1942. Now, these were issued by the military through the West Coast Defense Command, and in it hereby ordered that all persons of Japanese ancestry, including aliens and non-aliens, were to report for registration and eventual evacuation. Now, that's a pretty disturbing use of the English language, because we all know an alien is a foreign national. So what's a non-alien? Is that a citizen? That's kind of scary. That gives a really terrifying insight into the view of the government and the military about citizenship and rights. And obviously, this violates due process, this whole business about report for registration and then later transportation. Holy cow. Now, this also is scary because it violates the Fifth Amendment's protection of civilians having to be put under military law. Now, it also violates the Fifth Amendment protections of property rights, because since the Nikkei were forced to leave with so little notice, what do you do with all of your possessions? Well, in many cases, there were these big sales where people tried to unload all of their stuff through kind of garage sales. And since these evacuation orders were posted in public, everybody knew the Nikkei were being forced to leave. And so whether it was household goods or inventory from a store, the Nikkei were offered a pittance for their belongings. Now, if they really wanted to be cheap, that some people could just wait till they were evacuated and then loot the house or loot the store. Now, some people here in San Diego did try to preserve what they could of their durable household goods, like furniture and things like that. So before evacuation, they actually took a lot of their goods to the San Diego Buddhist temple, stacked it up in the temple, and then locked the doors and hoped for the best. Well, in January of 1943, somebody robbed the temple, and then to hide the fact that the temple was robbed, they firebombed the place. So much for protection of personal property, and that's guaranteed by the Fifth Amendment. Now, this back to this issue of the protection of the Fifth Amendment that provides against the civilians being subject to military law. Even though the government went to great lengths to downplay the military nature of the internment and evacuation, there is no denying that this was a military operation. It was carried out by the military with armed guards. They just did their best to make sure the American public never saw this. And what ended up happening was, in this first phase of the internment, people were moved. The Nikkei were moved into these concentration camps, and the War Relocation Authority did call them assembly centers and later relocation centers, but in military documents they refer to them as concentration camps, and so I've got no moral problem using them, especially when you look at physically how they're set up. Barracks, living, luggage searches, armed guards, barbed wire. I mean, this is a concentration camp by anybody's definition. And eventually, it goes from an assembly center concentration camp that was near to the area where the Nikkei originally lived, and then they were moved to areas further inland in really desolate and really isolated places where they had the same, if not worse, conditions as far as barbed wire, armed guards, and in this case, complete and total isolation. So that wraps up my part of the Japanese American experience and the Constitution.
Okay, thank you. Thank you, Matt. That's a huge amount of really, really great information. And the good news is that you'll be able to review it. I took copious notes, but it's a lot. I'd like to encourage participants to put your questions to Matt in the chat or Q&A, and we'll address those later. And so now I invite Professor Susan Hasegawa to begin her presentation.
From, quote, assembly centers, Japanese Americans were transported to prison camps, euphemistically called relocation centers. There were 10 War Relocation Authority camps, WRA camps, commonly called, with 120,000 persons of Japanese ancestry, American citizens and immigrants. And again, American citizens were locked up behind barbed wire, imprisoned, many of them for the duration of the war. 27 Department of Justice camps with over 5,500 Japanese immigrants, Issei men, community religious leaders, fathers, uncles, and some of them did not see their family for years. These camps were in barren and isolated areas. This is then a picture of the Department of Justice, or DOJ camp in Santa Fe, New Mexico, and you notice they're all men. Again, older Issei men, community leaders, or people who were thought of as community leaders. In Poston, Arizona, in the middle of the Arizona desert, where most of San Diego's Japanese American community were incarcerated, they ended up building their own schools, their own gym. And Issei women found jobs that were paid very little, but at least it was a job. And we'll come back to this issue of wages again, because they really didn't have any choice. This was, again, remember, a prison. And this is the view from then the water tower looking down at Camp 3. And in the distance, you can see then another camp. There were 3 camps, Camp 1, 2, and 3, with almost 18,000 American citizens and their immigrant parents. People had to create their own homes. So this is a garden that people created. But again, make no mistake, people could not freely go in or leave. Everything was guarded by the military police. You had to get passes to leave, permission. Soldiers, US soldiers in their army uniforms had to get permission to visit their parents from the camp director. In 1943, the government came up with a loyalty questionnaire. If you answered this pages and pages questionnaire, you could get a job and then go to a city or place outside of the exclusion zone in the inland states. 2 questions were very, very divisive and confusing and brought a lot of frustration, anxiety, and stress among the incarcerees. Question number 27, are you willing to serve in the armed forces of the United States in combat duty wherever ordered? Old men were saying, am I going to be forced to carry a gun? Women asked, are we going to have to serve? Question number 28, will you swear unqualified allegiance to the United States of America and faithfully defend the US from any or all attacks by foreign or domestic forces, and forswear any form of allegiance or obedience to the Japanese emperor or any other foreign government or organization? American citizens said, we're already Americans. We're already loyal to the United States. I mean, why do we have to swear something which we have told people time and time again? Issei looked at that and says, well, wait a minute. If we say yes to these, then we will be a people without a government. we're no longer Japanese citizens and we can't become US citizens. US citizens said, American citizens said, I have never had allegiance or obedience to the Japanese emperor to begin with. Your only choice was yes or no, 27, yes or no to 28. And so this caused a lot of conflict. And many people said yes, yes, went out, got a job outside of camp. You also had young men who said yes, yes, they volunteered for the US Army, or later on they were drafted. And this is an image of a bunch of Nisei in Chicago, some of them in uniform, others then who are working in Chicago. Now, Nisei and the military. Nisei then were in a segregated unit, the 442nd Regimental Combat Team and the 100th Battalion, who served valiantly and with courage and bravery in the European theater. They are known as a Purple Heart Battalion because of their numerous casualties. The Military Intelligence Service, MIS, were translators, bilingual Japanese-English translators who then served valiantly, courageously, and helped them decrease the duration of the war out in the Pacific. Under the US Constitution, and this is what many Nisei said, we're American citizens, we have rights. Under the US Constitution, you have the separation of powers. You have the legislative branch, the executive branch, the judicial branch, and you have these checks and balances. But in this case, the US Constitution failed Japanese Americans and Japanese immigrants. The executive signed Executive Order 9066, which allowed the military to secure the West Coast from espionage and spying. And again, there were no cases of espionage or spying with the Japanese American or Japanese immigrant population. Nonetheless, forced evacuation and incarceration happened. Congress passed Public Law 503, which imposed punishment and fines for then if you went against Executive Order 9066. Lastly, the Supreme Court, SCOTUS, Supreme Court of the United States, then decided on 3 key court cases in support of the US government and the US military. Dissent. And what I want to focus on is not just the Supreme Court cases, but then taking a look at the US Constitution. So, dissent. There was 3 Supreme Court cases. Hirabayashi versus the United States. Gordon Hirabayashi was a university student in Washington State, and he violated the curfew. Minoru Yasui was a lawyer, so he knew his rights, and he violated the curfew. They were both arrested, prosecuted, and this went all the way up to the Supreme Court. And the Supreme Court, in unanimous decisions, sided with the government. Now, Korematsu v. United States, Fred Korematsu, he did not leave when all of the San Francisco's Japanese American population were forcibly removed. He decided to stay. He was caught, arrested, and prosecuted. And in the Korematsu decision, the Supreme Court decided 6-3. So there were 3 dissenters. 6-3 in favor of the US government, that this was in time of war. It was a necessity for the US government to take the actions that it did in evacuation and incarceration. Now, they never actually mentioned that. They just said the US government has to do what it needed to do. So Korematsu had 3 dissenters. And let's take a look at what the dissenters said. Supreme Court Justice Robert H. Jackson said, Korematsu was born on our soil of parents born in Japan. The Constitution makes him a citizen of the United States by nativity and a citizen of California by residence. No claim is made that he is not loyal to this country. There is no suggestion that apart from the matter involved here, he is not law-abiding and well-disposed. Korematsu, however, has been convicted of an act not commonly a crime. It consists merely of being present in the state whereof he is a citizen, near the place where he was born and where all of his life he has lived. Okay, so Jackson is saying, this what are we doing here? He's an everyday person living his life, but he's convicted of a crime. Justice Owen Roberts, in his dissent, said, "It is a case of convicting a citizen as a punishment for not submitting to imprisonment in a concentration camp." Note, Roberts uses the term concentration camp because that's what the government called then these relocation centers, concentration camps. Based on his ancestry and solely because of his ancestry, without evidence or inquiry concerning his loyalty and good disposition towards the United States. If this be a correct statement of the facts disclosed by this record and facts of which we take judicial notice, I need hardly labor the conclusion that constitutional rights have been violated. So Roberts is concluding constitutional rights have been violated with the arrest, prosecution, and conviction of Fred Korematsu. Justice Frank Murphy, in his dissent, he said, "I dissent, therefore, from this legalization of racism. Racial discrimination in any form and in any degree has no justifiable part whatever in our democratic way of life. It is unattractive in any setting, but it is utterly revolting among a free people who have embraced the principles set forth in the Constitution of the United States. All residents of this nation are kin in some way by blood or culture to a foreign land. Yet, they are primarily and necessarily a part of the new and distinct civilization of the United States. They must accordingly be treated at all times as the heirs of the American experiment and as entitled to all the rights and freedoms guaranteed by the Constitution." So let's take a look at these guarantees under the Constitution. First Amendment, restrictions on the power of Congress. Okay, and this is again, First Amendment, freedom of speech and the right to assemble. First Amendment states, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or the press or the right of the people peaceably to assemble and to petition the government for redress of grievances." Well, incarcerees definitely did not have the right to assemble. It was restricted. They were prohibited from having mass meetings, and English was required to be the primary language. First Amendment rights were violated under the guarantee of freedom to petition for redress of grievances from the government. The WRA targeted people who spoke out against the government's policies. These troublemakers were sent to isolation camps. Fourth Amendment. In the Fourth Amendment, we have the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Those shall not be violated, and no warrant shall be issued but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So we have the freedom from unreasonable searches and seizures. The FBI searched homes of Japanese Americans, often without search warrants, seeking any type of items, that identified them as Japanese. Things like swords were confiscated. Anything the FBI deemed as contraband, like shortwave radios, they were confiscated. So all kinds of things were confiscated. Books in Japanese were confiscated. Fifth Amendment violations. No person shall be held to answer for a capital or otherwise infamous crime, unless on a presentation or indictment of a grand jury, nor shall be compelled in any criminal case to be witnessed against himself, nor be deprived of life, liberty, or property, without due process of law, nor private property be taken for public use without just compensation. Okay, so we have the right to an indictment or be informed of charges. We have the right to life, liberty, and property. Forced removal and incarceration result in denial of witnesses in, people's favor. Okay, so people couldn't call witnesses. There were no trials. and denial of assistance for their defense. They couldn't even mount a defense because, again, there was no indictment, no charges brought to people. Japanese Americans were picked up by this FBI sweep, the fathers, the uncles. They were denied access to any legal representation. They could not call upon witnesses. Japanese Americans were not told of their crime or the charges against them. Fifth Amendment violations, and the dissenters on the Supreme Court saw this. Eighth Amendment, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Treatment in camps were a form of cruel and unusual punishment on the basis that conditions were grossly inadequate. Dr. Roy Tanaka, he talked about a child dying in his care because he did not have adequate equipment to treat the child. Hospitals were understaffed and medical care poor. Eighth Amendment, 13th Amendment. And the 13th Amendment abolished slavery after the Civil War and states neither slavery nor involuntary servitude except as punishment for crime whereof the party shall have been duly convicted shall exist within the United States or any place subject to their jurisdiction. Okay, again, people were not convicted. There was no trial, yet their only alternative to try to make a living was to work for the WRA. And payment for work was way below the monthly average outside of camps. Dr. Roy Tanaka could make at the most $19 a month. That was the wages of a private in the Army. The lowest wage of a private in the Army, that was the most that Dr. Tanaka was paid. 14th Amendment. 14th Amendment has to do with citizenship and payment of public debt. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall make or enforce any law which shall deprive any person of liberty, life, or property without due process of law, nor deny to any person without its jurisdiction equal protection of the law. Let me read that one more time. 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall make or enforce any law which shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction equal protection of the laws. So equal protection of Japanese Americans was violated because the government acted solely on the basis of race and national ancestry. Again, racial profiling. So they identified persons of Japanese ancestry. They were the ones to be excluded from these military areas along the west coast and southern border of Arizona. The government failed to compensate or provided grossly inadequate compensation to internees for losses of property rights when they were forced to leave, sometimes within 48 hours to a couple of weeks. Japanese Americans were deprived of their liberty and property by the state when forced from their jobs, homes, and communities. And not to mention having to come back and restart their lives after years of imprisonment. Takeaways. Japanese Americans were limited in their political voice and had no representation. People didn't stand up for them. In fact, the San Diego City Council supported what was going on. They had passed resolutions in support of forced evacuation. Thus, vote on November 8th, okay? The Nikkei were just coming of age. They were having these voter registration drives in the 1930s. They were having candidate forums in San Diego in the 1930s, late 1930s. Okay, again, no representation, limited political voice. So get out the vote, get educated on the issues, and vote on November 8th. Second takeaway, scapegoating of the other. Japanese Americans, Japanese immigrants were blamed for the war which they did not cause. We have a history of scapegoating people and blaming them for all the ills of society, all the problems. Finally, we do have a very fragile democracy. So again, get out and vote on November 8th. Now, on the positive aspect, the story doesn't end with World War II and people getting out of camp. And what is ironic, as the Korematsu decision is coming down in late 1944, the government was already making plans to lift the exclusion zone and let Japanese Americans and their immigrant parents start returning to the West Coast. So starting in January 1st, 1945, people could leave. And people did. Like Dr. Roy Tanaka, he came back to San Diego, restarted his practice, put his life back together. Fast forward to the 1970s and 1980s. The Japanese American community started mobilizing and organizing. Through the courts, Hirabayashi, Yasui, and Korematsu's decisions were vacated, meaning they were deleted. Finally, redress and reparations, which our next speaker will talk about. Thank you. After the war, there was a case then that finally looked at the Oyama, or the alien land laws. And in 1945, the Attorney General of the state of California started going after Japanese Americans, the citizen children, with their names titled to the properties, especially agricultural properties. And so the Japanese Americans fought back, or their Issei parents. And in this famous case called Oyama v. California, it came down in 1948 that the alien land law based on the 14th Amendment did not provide equal protection. Therefore, the alien land law, where Nisei children, American citizens, could hold title to property bought by their parents. So in the post-war period, you have the Japanese American community chipping away then and regaining rights that other American citizens have. And again, this Oyama in 1948, the Supreme Court decision then was a foundational stepping stone to then the Brown v. Board of Education. I'll take it back to Kay and she can talk about reparations and some of the issues happening right now in San Diego.
Thank you, Sam. And thank you, Susan. Both you and Matt presented tremendous amounts of issues that I think I invite everyone to go back when this YouTube video becomes a YouTube and is available to everyone, to go back. It's just dense with important information. But I'm well aware of the time and want to just say that when we edit this program, we will edit out the delay earlier. So for the purposes of a more coherent program, I'm going to go ahead and proceed. And if people have to sign off, I do regret that, but I do understand. So in addition, again, of course, to thank you, Matt and Susan, for all of this research they've done, that we know that number one, our history, Japanese American history, was not recorded. Certainly, about the war. I knew nothing about it when I was growing up. And it wasn't until the civil rights movement and the redress movement that things, began to become written about and talked about. I do want to say that common people like Mr. Oyama, he was a farmer. He stepped up and had the courage to file that court case. Good that A.L. Weirin, his name is Abraham Lincoln Weirin, how great is that? He stepped up and assisted Mr. Oyama. People like Fred Korematsu, he was not an academic. He was a regular guy. He was a blue labor guy. He stepped up and challenged the Constitution. So there are numerous heroes out there. And we'd like to share more and more about those people. But I think that I just do also want to remind that Executive 9066 was an executive order. And it's important for us to think about and focus upon the fact that the president has unlimited power, especially during wartime. And that is what some of the decisions of the Supreme Court hinged upon. That exists today, okay, through the National Defense Authorization Act, which was reauthorized maybe about 10 years ago. I want to say that the president has unlimited wartime powers unless they're challenged by Congress and the people. And finally, I think that although I'm not able to talk about redress and reparations very much, the court cases of Hirabayashi, Korematsu, and Yasui were rescinded or vacated is a term in the early 1980s. This coincided with the redress movement and was a huge, powerful impetus for Congress to keep pushing forward because the Supreme or the courts were now behind it and had, righted this wrong. So there's a lot more to say about that topic, but I'm going to pivot now to the late breaking news that on Tuesday, 3 days ago, September 20th, I was witness to the San Diego City Council rescinding a very anti-Japanese, very racist resolution they unanimously passed in 1942. And it stated primarily that in San Diego and vicinity, many enemy aliens, especially Japanese, it states, whose continued residence here is considered inimical to the best interests of this vital defense area. It goes on to say, and there is great cause for concern due to the existence of subversive elements, of known subversive elements. That is so wrong. That was proven not to be true. And so just 3 days ago, the San Diego City Council did rescind this. It was a great day. And I have to give a huge shout out to the San Diego Public Library librarians. They found this information while doing research along with Susan Hasegawa when they were curating the Clara Breed exhibit. They found this historic resolution and they took the ball and ran with it. They are librarian activists. I salute them. They wrote a resolution to rescind. They sent it to the JACL and to the Historical Society to get our input. They sent it on to City Council, and it took a bit of time, but with the Historical Society, working with Council President Elo Rivera, we were able to see this great historic moment just a few days ago. So I do want to say that with effort by lots of people, the US Constitution, a brilliant piece of writing must be protected. It must be defended. And who's going to do it but us? So although my notes are now sort of skewed, I would like to really wrap this up and kind of segue into the Q&A portion. And
reminder here, use that Q&A so that we can take your questions. And I see a couple coming through here. Any questions that you've got about this content or any of our speakers today, we would love to hear them, and we would love to be able to answer them.
And if I could, I'd like to just add to the discussion here, since we have covered a lot of material and it is kind of dense. So Susan did mention, Nikkei mentioned about how Korematsu, Yasui, and Hirabayashi were all exonerated and their convictions were vacated. What I think is the big picture issue that we need to remember is those rulings applied only to those three individuals. So yay for them, but unfortunately the rulings did not touch on the constitutionality of the internment and Executive Order 9066 itself. So what this means is that even though 9066, the specific executive order, was rescinded, I believe by President Ford, right, Susan?
Yes.
And then Ford's administration, but the power that was given to the president has never been overturned. So the Supreme Court cases of Hirabayashi Hirabayashi and Yasui still stand. So that precedent is still standing precedent. And we mentioned this in one of the last presentations that we did together, that there was the Supreme Court case of Trump v. Hawaii, where about President Trump's travel ban from so-called Muslim countries. And Justice Sonia Sotomayor had put in her dissent, because the court said, yes, the president can do this. It can, ban people from specific countries. Justice Sotomayor had said that this decision is scary because it uses the same basic argument that was used in Korematsu. And John Roberts, the Chief Justice, had said, well, one, you're wrong, but two, he said that Korematsu was wrong when it was decided, and it's been kind of vacated in the court of history. The problem is Korematsu was not at issue in Trump v. Hawaii. So basically what Roberts did at that time was he made kind of almost a public relations argument rather than a legal argument. So as far as legal scholars go, Korematsu, Hirabayashi, and Yasui are still all cases that uphold the government's power to do things like the internment. So I hate to be a Debbie Downer, but as Kay said, this is one of the reasons that in democracies you really need eternal vigilance. Otherwise, bad things can happen.
Right.
We do have a couple questions coming in. There are two related to FDR, it looks like. So how does FDR play into this? He was the president. And then there's a follow-up I think might go with that question regarding veto power and nobody canceling this. But maybe we can talk a little bit about that.
Would Susan or Matt like to? I do have a thought about FDR, but.
Sure. Well, at the time, he basically delegated the decision. He said, I'll sign the order, and people in the administration wholeheartedly supported it. The War Department was pushing for it. Military was pushing for it. Californians themselves were pushing for it. And so you had all the civil leaders in the state of California supporting it. And so FDR says, sure, I got to go fight a war. Okay, I have other things to do. And basically, civil rights or civil liberties just went out the window. It was a very low priority for the Roosevelt administration, Roosevelt himself.
Yeah, and as far as the veto, you have to remember it's an executive order, so it comes directly from the president as the head of the commander-in-chief, and also under Article 4, Section 4 of the Constitution, where it's kind of the job of the federal government to maintain, kind of law and order. The only check on an executive order is the Supreme Court. Someone's got to sue. And I forget, in one of the dissents, the name's escaping me, but one of the arguments in the dissent in one of the big cases was that this ruling is dangerous because it gives the government this carte blanche power. They're not saying that, and again in the dissent they said that the government can still have this power in a time of emergency, but to go ahead and approve it like this, have the court give it the court's imperature sets kind of a scary precedent, because you can, now it's saying, yeah, this is okay all the time, no matter what. So I hope that kind of answers the question about a potential veto. It's just not subject to a veto, again, other than a Supreme Court ruling. And
I'd like to add about FDR that, as Susan mentioned about the California forces, a lot of it was economic. All right, this is a huge, huge factor that doesn't get talked about often. And that is that Japanese immigrants worked so hard to work the land. They prospered and had really, really made huge gains in the agro business. And they became powerful in that way. A lot of the primarily white unions and farm organizations really were reacting to that newfound power of these immigrants and really lobbied hard for Governor Warren in California, as well as FDR, to get rid of these people. And by doing that, they were able to, benefit greatly with their businesses, gaining land, etc. It's a huge, huge factor that, deserves a lot more attention.
Yes, and there's actually an FBI presentation that was given to the San Diego Chamber of Commerce in 1942, where even the federal government admitted that, yeah, it would be great if the white farmers could take over. And they flat out said that and even offered. Now, there's no evidence the offer ever was taken up, but there was an offer of federal assistance to the white farmers after the Nikkei were taken off the West Coast. So Yeah, as Kay said, there's a lot of economics at play here. Follow the money.
Mhm.
I'd also like to jump in, which I didn't add in the Supreme Court cases, was the government lied. Government lawyers withheld information that said there was no espionage or there were no spying, or the Japanese immigrant community and Japanese Americans did not present a danger to the West Coast. And so that was part of vacating the Korematsu, Yasui, and Hirabayashi decisions, was evidence that the government lied.
Yeah, I shout out, we're just like, oh, we just love this conversation. I'd like to shout out to Professor Peter Irons. He is a professor emeritus at UC San Diego and is still amongst us, and spoke just last fall. Susan was the MC of that program with the Clara Breed exhibit. Professor Irons spoke about, his important contributions that he and a Japanese American woman, Aiko Hertzik Yoshinaga, were doing a lot of research, deep dives into National Archives, the history. They found the documents that showed, they were literal documents that showed that, the naval intelligence was saying there was no, Japanese were no problem. And so when they found that document, we like to call it the, smoking gun, that really, really kind of shot down all those conservative arguments. And once again, regular people amongst us, working on something to right a wrong. I so indebted to them. So.
Yeah, I see a question in the Q&A about the Trump v. Hawaii. When I was mentioning Trump v. Hawaii, obviously I personally disagree with the court's decision and with the president's decision, but the issue I wanted to bring up though was that Sotomayor in her dissent had brought up the Korematsu case, and then Roberts had answered it. And then some legal scholars have said, well, since the Supreme Court, the majority decision had included this mention of Korematsu, does that invalidate 906s, and does that invalidate Korematsu? And again, I want to go back to the point of no, it does not. So for the person who asked the question about Trump dealing with citizens, my comment was not so much about Trump v. Hawaii itself, it's about the issue of how that applies to Korematsu, and does the Trump v. Hawaii decision overturn Korematsu in the other cases? And again, the answer is no, it does not.
It looks like we've got another follow-up to that same conversation, asking, were Japanese votes really taken into consideration, given their limited rights at the time?
No. Again, the Nisei, many of them were underage. You have a small group who have started to become politically active, but just a really small percentage of the population. So no, are they a political voting bloc that politicians will listen to? No.
But the reason I went into such a long kind of discussion of the 14th Amendment, equal protection of the law, and then earlier case law with the Chinese is the government should have. Like I said, under constitutional and case law, the 14th Amendment, equal protection of the law, applies to even the Issei, to non-citizens. So that was the point I was trying to get at with there. And I think that's kind of the whole discussion we need to have about the internment itself. A lot of people like to say, well, there was a war on and it was just military necessity. But both history, and like I said, case law and constitutional law pretty much showed that was not the case. It was racism and economic pressure, with a bit of wartime hysteria thrown in. But I would argue that the wartime hysteria is often overplayed. And as Susan pointed out with the dissents, the multiple dissents in the Supreme Court cases, this idea that that's just how everybody felt. And I want to mention this because I've seen this lately in kind of the blogosphere, where one of the defenses of things that today we consider are really quite racist or imperialist or whatever is, oh, that's just how everybody felt back then. And I could argue, well, no, there's a fair number of people, including some fairly respected intellectuals, who said, this is not acceptable. This is not the right thing morally or constitutionally to do. It was just that people did not follow the ideals of the United States. We've got great ideals when we live up to them.
So it's important to reiterate the importance of you in the audience today, young people, learning as much about the US Constitution, our rights as possible, so they won't be infringed, especially in your case. I do want to say to Octavio Garcia's question, I don't know the numbers of Japanese Americans in the Imperial Valley, but we can certainly find out, which leads me to a point. We would like to hear from you, perhaps in the Q&A or through your professors, about other topics that you would like us to address specifically, because it would be our pleasure to try to speak to these important questions that you may have. So please stay in touch with us, and future programming, there's a lot of work to be done.
I also included my email in the chat. So if you want to reply to the follow-up email that you get, or directly, or in the Q&A here, or any other way to contact us, please do. But know that email directly is an option. It's in the chat, JAHSSDprograms@gmail.com. That comes directly to me, Sam, and I will share that with Kay and anybody else that we are combining with to create new programs. And we would love to hear from you on things you want to know more about.
I don't know that there are more questions. Susan and Matt, are there any closing thoughts you may have, or?
Say, remember to vote.
Yes.
Register to vote. If you're not registered, get educated on the issues and, be an informed citizen.
Right.
If you're not eligible to vote, you can still advocate for issues and people you feel strongly about and align with your political viewpoint and your worldview. So remember to vote.
Thank you. And I'm going to just take it upon myself to read part of the City Council's apology to the Japanese American community. Their apology, part of the resolution, states, the City of San Diego apologizes to all people of Japanese ancestry for its past actions in support of the unjust exclusion, removal, and incarceration of Japanese Americans and residents of Japanese ancestry during World War II, and for its failure to support and defend the civil rights and civil liberties of these individuals during this period. It is a time of sort of reparations. I think in the broader community, you'll see reparations actions happening all over the state and country. Even this weekend, the AB 3121 task force of California that's assigned to study, the root causes of slavery and the impact on our Black community is happening, as we speak. I'll be tuning in, and I do know that part of the lessons of our community is that many of us support the struggles of other people of color who have been similarly targeted. I think this is hugely important. You see all kinds of actions for repair happening throughout the country. I think the time is right. I think San Diego City Council, 80 years later, but it was a great thing. It's never too late to apologize and set things, on the correct path. So I think that will have to probably be our wrap today. To thank you all, and please do participate with our survey in our way of thanking Cal Humanities for the grant, and hopefully it had some, good impact. And so with that said, I thank you all and have a great rest of the day.